Hello, and welcome to today's episode. If you're listening, there's a good chance you or someone close to you is navigating separation, thinking about separating, or you simply just want to understand how family dispute resolution works in Australia. First, I just want to say you're not alone. Okay, separation can feel overwhelming, it's emotionally draining, it's confusing. My goal today is to try and walk you through the key things you need to know about family dispute resolution, parenting plans, Section I certificates, in a way that's clear, practical, and hopefully a little reassuring. So let's get started. So first of all, what is family dispute resolution? Well, it's often called FDR, and it's a structured confidential process that helps separating families resolve parenting or property disputes without going to court. It's facilitated by an Accredited Family Dispute Resolution Practitioner, or FDRP. Think of FDR as a conversation with purpose, okay? It's not counselling and it's not about getting parents back together. It's about helping parents move forward. An FDR practitioner is not a judge. An FDR practitioner will not tell you what you should do or decide for you what the future should look like. A practitioner will help you identify the issues that you're struggling with, help you explore different options, and reality test some of your ideas. It's an opportunity to negotiate agreements that are safe, workable, and focused on your children's well-being. And that's important because one of the most important things to understand is that the Family Law Act requires parents to make a genuine effort to resolve parenting disputes through FDR before they can apply to the court. Okay, so this is where Section 60Is come into play, and we'll talk about that in a moment. But before that, let's talk about the heart of FDR and what actually happens. So it usually happens in stages, and I want to break this down for you because many people feel anxious before they start, and it's hardly any wonder. There's a lot of new terminology and a lot of things that most people haven't experienced and wouldn't understand until they're involved in the process. So first of all, there's the initial contact. So this is where either yourself or your ex-partner will contact an FDR service such as mine, and you'll be asked for basic information so we can understand what type of help you might need. Okay. Then we have the intake sessions. Each person meets individually with the mediator, and this is a completely private and confidential meeting. Your ex-partner's not there, nothing gets repeated to anybody. It's a confidential conversation between yourself and the mediator. These conversations allow the mediator to understand your story, to assess safety risks and determine whether mediation is suitable or not, to learn about your children, to understand what you want to achieve in the mediation, and it's an opportunity for us also to explain the FDR process to you and answer any questions you might have. So this is a really important step because family dispute resolution only goes ahead when it's appropriate and safe. So if both parties are suitable for mediation, we then schedule a joint session. A typical mediation takes around 3.5 hours, and it's usually held online or in person if that's your preference. It involves a structured conversation which is guided by the mediator. The focus is heavily on the children's needs. The mediator helps you both stay on track, stay respectful, and work through the topics that are most important to you. Parenting arrangements, communication, school holidays, travel, special events, anything that you need to have an agreement on. There's no judgment, there's no blame, and there's no taking sides. This is very important to understand that the mediator is entirely neutral. We're there to assist both of you equally. It doesn't matter who contacted us first, you are both our clients, and our goal is to help you come to an agreement. If you reach an agreement, it can be written up as either a parenting plan, or it will initially be drawn up as a parenting plan, which you can just have a parenting plan that you both sign. It's informal and it's not legally enforceable. But you can also have that parenting plan formalised into consent orders, which make them legally binding. So your mediator will explain the differences and help guide you towards what suits you in your situation. What you need to know about parenting plans is that a parenting plan is a written agreement that sets out how you will co-parent moving forward. And it's incredibly useful for reducing conflict, creating stability, providing structure, and helping children feel secure. And importantly, it's flexible. Okay, so a parenting plan can be updated as the children grow up and things change or your circumstances change. It's a simple matter of you discussing the changes that need to be made and both initialing them, and that's enough on a parenting plan. At its core, a parenting plan outlines the who, what, when, where and how of co-parenting, okay? So it can include weekly care schedules, time spent with each parent, school pickups and drop-offs, holiday arrangements. Communication is a big one that's always included in a parenting plan, how the parents are going to communicate. Introducing new partners and what that will look like. Health and education decisions, how you will handle disagreements. This is really important too because I think it's important in a mediation for the mediator to assist you, not just to come up with a parenting plan for the specific things that you can think of on the day, but also to discuss how you're going to deal with disagreements in the future. So if there's a disagreement about the breakup of the school holidays, who's having the children on what dates, how are you going to manage that? Is that something that's going to be done via a parenting app, or are you going to have a phone conversation? If you can't agree on the dates, what then? How do you come to an agreement? So those things are all very important because you don't want to have to be coming back to mediation every time you disagree about an arrangement. You need to know how to manage it moving forward. The best parenting plans are child-focused. They're practical. They need to be clear, predictable and realistic. Okay, so I want to talk about why parenting plans are so effective, because they really are. To put it simply, parents often worry, what if the other parent doesn't follow the plan? Well, parenting plans are not legally enforceable the same way court orders are, but they are considered by the court as evidence of the parent's arrangements and intentions, right? So you can have an informal parenting plan that you've both just signed, it's not legally enforceable, but if it all turns to dust and you end up in court, the court will take into account any parenting arrangements that you've had in the past. So they will take into consideration what you've agreed on in the parenting plan. Most parents tend to follow them once you've got a parenting plan in place. It's really useful because it reduces the stress, minimises confusion, keeps things consistent for the children, and it minimises that conflict. If you both stick to the parenting plan, there's nothing to argue about. Common mistakes that are made in developing these parenting plans. Some of them might surprise you, but these are some of the ones we see most often. Being too vague is a big one, okay? So saying we will share school holidays is very vague. How much of the school holidays? How are you going to pick up and drop off? What time of day, what days of the week, etc. It needs to be very specific. Communicate regularly. Well, that doesn't set clear expectations, okay? So are we talking about communication with the child when the child's with the other parent, or are we talking about communication between the parties and what is acceptable communication and what's not? So yeah, not being too vague, that's an important one. Another one is when parents tend to try to design a plan around their own convenience instead of the children's needs. The plans should absolutely centre around the children's best interests. There's an important note to make there. When you come to a mediation, you need to be coming with a reasonable proposal, okay? Because if things don't work out in the mediation and you end up in court, what the court are going to consider are the child's best interests. So you should be doing that too, because when you get to court, whatever you present in court, the court are going to be looking for you to be putting the child's best interests first. So there's no point coming to a mediation trying to negotiate things that are not in the child's best interests. Another common mistake is not planning for change. Kids grow, your work schedule changes, life happens. You need to build in flexibility where appropriate. So as an example, you might have a clause in there that says that your child will be collected by the father from school on a Friday afternoon at 3:10. and then something happens with the father's work schedule and he can no longer do that on a Friday. So you need to be able to be flexible to come up with a different arrangement that works for everybody. Maybe the child goes to after school care and the father picks the child up at 5 o'clock, or maybe the mother picks the child up and the father has the child from Saturday morning. You need to be able to have flexibility there. Not addressing communication methods. It's really important in every parenting plan to address communication, because if communication is a source of conflict, you need to address how you're going to manage that. I touched on this earlier. So a lot of couples will have discussions around the type of communication, whether all communication should be purely by email or the parenting app if you have a co-parenting app. And your mediator can guide you through all of that so you're not left guessing and having to make a decision on the hop. But you need to think about, is it appropriate for you to be calling one another, or would you prefer texts or WhatsApp groups for where there's step parents involved? That can all be put in the parenting plan too. So I'm going to move on now to explain Section 60I certificates. So a Section 60I certificate is issued in various circumstances. The first one is when Party A contact us to have mediation with the other party, and they refuse to attend. If one party refuses to attend mediation, the Party A is issued with a Section 60I certificate. The Section 60I certificate simply tells the court that you have attempted mediation, and it's a tick the box form where we tell the court why mediation didn't happen. So it's either you didn't attend mediation because the other party didn't attend, or you didn't attend mediation because the intakes were conducted and the mediator decided that it wasn't appropriate for mediation. There is nothing disclosed to the court in the Section 60I, so they will simply get the reason why it wasn't appropriate, but they get no detail about conversations that were held or information that was provided by the parties. That's for you to talk to the court about. Okay, so another reason might be that you've attempted mediation but just couldn't come to an outcome, couldn't agree on it, so now you have to go to court. Or another one is, we talked before about genuine steps. Everybody is required to make a genuine effort to resolve the matter. If I feel, or if any FDR practitioner feels that one party is not making a genuine effort, they may stop the mediation and issue a Section 60I. So you can't just turn up to a mediation to tick a box and say, yes, I tried. You have to actually make an effort. Sometimes the Section 60I will be issued because it's not appropriate, and one of the most common reasons why it wouldn't be appropriate to have mediation is if there's been significant family violence or there's a significant power imbalance recognised in the intake process. We can't conduct a mediation with two people where the power imbalance is so huge that one party is nervous about responding to the other party, or one party won't say what they want because they're in fear of the repercussions from the other party. We would deem that to be inappropriate and issue a Section 60I certificate and ask the court to deal with that. So the certificates are important because they allow you to access the court system, but the courts, as I've said, expect that you have genuinely tried to mediate first. They also show the court how each party engaged with the process. So if you reach an agreement, obviously you don't need a Section 60I certificate. One of the questions I often get is, do I need to mediate again if things change later? Well, sometimes. If a dispute arises down the track, you may need a new mediation attempt to potentially resolve the issue or issue a certificate. But normally, personally, I have found in my experience that most people, once they're able to get their parenting plan documented and they work with it, they're usually able at that point to negotiate changes to the parenting plan. As I said before, a good mediator will give you the tools to work out how to negotiate disagreements moving forward without having to come back to mediation every time. But having said that, sometimes there are situations where a couple that have a parenting plan might come back to mediation for a shortened version of a mediation, probably a 1 hour mediation, to talk about one particular issue that they can't get over. And that's certainly an option that's open to you. The key thing to understand is that the system is designed to support parents and to resolve disputes without going straight to court. So whatever we can do to assist in that process, we are available to you. I know some people, when they first come into this, feel as though the FDR process is just a ticking the box process, but I can tell you it works. The FDR process really does work. It's effective because it's quicker than court. It's certainly less expensive, less time consuming and less draining. It's also confidential, it's child focused. And to me, one of the most important things is that you maintain control over the decisions. Okay, so you come to mediation. If the two of you can come to an agreement on what co-parenting together looks like moving forward, you get to make the decisions about your children's future and about what that looks like for you and your children. If you can't come to an agreement in mediation and you go to court, the judge is just going to tell you what's going to happen and you won't get a choice. You won't get to argue about it. He or she will just tell you, these are the orders, this is how it's going to look. I know personally I would rather be making those decisions for myself. However, FDR isn't suitable for every situation. I touched on this before. If there's significant family violence or safety concerns, huge power imbalances, we would issue a Section 60I and ask the court to deal with that. Also, it can be difficult and not appropriate to mediate with couples where the communication is completely broken. If every time you try to have a conversation it ends in a fight, it's probably going to be quite difficult to mediate. We do have options around some of those issues if it's not too severe. If there's just a discomfort and a communication breakdown that means it's very difficult for you to have a conversation in the same room, we can do what's called a shuttle mediation, which means even online in a Zoom conference, I can put you in separate breakout rooms and I would shuttle between the two of you. So you don't have to actually talk to one another. You talk to me, I go to the other room, talk to the other party, come back. It's a bit lengthy, but sometimes that's a good alternative for some couples. In any of these cases, the mediator will discuss any alternative pathways with you, which may include court or other support services. So I want to give you some practical tips for you if you're starting the process. The first tip, the most important thing to keep in mind at all times, is focus on the children. You need to think about their routines, their needs and their emotional well-being, and not just what feels fair to you. Okay, in these situations sometimes when you're separating, the divide has gotten so big and the conflict so tough that you find yourself just wanting to score points against the other person. You'll do anything you can to trip them up. Please don't do that. Think about your children. They are what's important in the parenting plan. You're not here to win points over one another. You're here to set up a future for your children. So come with that in mind. Be prepared. Bring notes, dates, schedules, any proposals that you may have in your mind. It really is a good idea to do this because I've seen many people come into mediation thinking that they've got it all at the top of their head, in the tip of their tongue, whatever. And then they come to mediation and it all falls apart because they get distracted by the conversation or something else and they forget things. Bring notes. Be open to options and try to be flexible, okay, to help create solutions. There's no point digging your heels in over something that's not that important. What you want to do is come to an agreement at the end. The other thing I would caution that I tell all my clients at some point in the mediation is if your ex-partner is supposed to pick the children up on Friday and something comes up and they want to change the plan and they send you a message and say, listen, I can't make it by 4 on Friday, is it okay just this one time? Could I pick the kids up tomorrow morning instead? That may be annoying to you. It may be short notice. It may be whatever thing it is that gets your goat about that. The thing to remember is there's going to be a time, sometime down the track, where you're going to want something like that, something similar. So the more flexible you are, the more flexible you can expect the other parent to be. If you're rigid in, no, the plan says you pick them up at 3 o'clock on Friday and I've got plans, even when you don't, you're going to run into problems in the future. The more you can be flexible with one another, and it also does a lot towards repairing the communication and the conflict between you. Just having that knowing that your ex-partner is going to be reasonable about these things can really repair a lot of damage and make you feel a lot better about each other in the co-parenting sphere. The next thing I would remind you of is to ask questions. So when you're through the FDR process, we're here to support you. No question is silly. It's for most of you likely your first time in this process, and we're happy to help. And finally, the last tip I would give you is please keep communication respectful. This will help your children more than anything else. I ask couples to be respectful in the mediation because obviously that helps that process go a lot more smoothly. But even in your day-to-day lives, even when you think, oh, we don't argue in front of the children, I don't say a bad word about my ex in front of the children, I don't, you might think you're doing all the right things, but if you're having a disrespectful relationship with your ex-partner and things are tense, the children will pick up on it. You need to try and find a way to get along. So in conclusion, separation is a major life transition and it's normal to feel uncertain, but you don't have to figure it out alone. There are so many services out there, and family dispute resolution being one of those services can help you move from a place of conflict to a place of clarity and give your children the stability that they need. Whether you're just starting to talk about separation or whether things have become complicated, getting the right support early can make a huge difference. Okay, if today's episode has given you some clarity or even just a starting point, that's fantastic. And if you'd like some personal guidance, we're here to help. So if you'd like more information or you would like to talk to somebody about FDR mediation specific to your situation, please give us a call at Canon Mediation. Our number is 0455 238 884. We'd love to assist you. You can also find more information on our website at www.canonmediation.com.au. Thanks for joining me today. Take care of yourself and I'll see you in the next episode.